Huh?
Thanks, ladies, for being here.
They've been snapping my picture all morning. As long as it doesn't have numbers
I want to see one with
underneath
a
it.
smile on her face.
How, you want a double shot?
Well, obviously you're happy with today.
I thought the judge was very charitable, yes. I did. I sent a lot of people to jail, and I wouldn't have, complained about it, but, I thought the result was charitable to me. I appreciate his indulgence. I do.
Hindsight is 20/20, Judge. How do you feel about Crawford's decision to say he would have went to bat to keep you in your judgeship?
See, he's viewing it from his point of view, a very practical point of view, because I would still be earning a living, and but it's an individual decision for everybody, and I could not sit on that bench and talk to a criminal defendant about his dishonesty with any sort of I don't know. To me, it would be disingenuous to do that. I hope to get these convictions cleared in the Court of Appeals.
Does that mean you intend to appeal?
Well, I'm certainly giving a lot of thought to it. Essentially because I've noticed some things now that I didn't notice at trial, being in the maelstrom. It really had nothing to do with the judge's rulings, just things that I should have caught myself.
Such as?
Well, in two of the counts, two of the items that I didn't report, for example, the question was, if you or your spouse operates a business, list the name of the business. And even though my wife was a one-half owner of Whiteacre North, the clear evidence presented by the state was that she took no part in the operation. And Attorney Tully testified to that, and the checkbook, the bank records would verify that she took no part in the operation. Then, in 1 out of 7 filings, I failed to list Lorraine National Bank as a creditor. Now, that was an oversight because I had listed it every other year. But in fact, because of the nature of the agreement, I was the guarantor under a separate agreement of a loan, and under the law, I am not a debtor and would not have been required to report that. I had over-reported it in the other 7 filings. Finally, in 2012, the question was, if you or your spouse owns or operates a business, list the name of the business. So while she was a one-half owner of Whiteacre North, under Ohio law, rental property is not considered a business unless you are actually in the business of renting property. That is your livelihood. It would be characterized more of an investment, but under the Ohio tax code, when they talk about income or loss from a trade or business, rental property in and of itself is not a business. So that answer was accurate, and I'd like the opportunity to present that to the Court of Appeals, as well as the merger of the offenses. And I'm hopeful for some success. I'm the only judge in Ohio that has ever been prosecuted under these statutes, notwithstanding failure to report or even failure to file a report at all.
Have other judges done that?
Yes. I read in one case that I cited on a different issue, a judge had made an investment in a private corporation, Wallabies Inc., a restaurant, had written checks, five checks totaling $150,000 and didn't report it. When his response was, "I forgot," he got a pass. There wasn't even the finding of a disciplinary violation. Currently, there's a justice on the Supreme Court who 1 year didn't file at all, and in other years failed to report debts that were taken to default judgments. And the only concern there is whether there will be some disciplinary action or not. He's not being prosecuted. So it's a rather unusual event.
So why do you think you were singled out?
Well, I was singled out because when Judge Rothgary visited the prosecutor's office and related to Prosecutor Will his knowledge that I was involved in criminal activity, that gave Will the opportunity to call for a special grand jury because of the credibility of a judge, not specifically Rothgary, but a judge. And although none of Judge Rothgary's accusations bore fruit, the investigation cleared me on everything that he related to the special prosecutor. I think that while they were at it, they thought, well, let's see what we can find, and found these 4 items that I hadn't reported, and were able to prosecute on that basis.
What do you think about Crawford's sentiments that choosing to represent yourself was a bad decision?
There's some merit to that, because I think I might have paid more attention to detail as a client if I had just been a client as opposed to an advocate. But, you know, what we were expecting the jury to do is differentiate between a debtor, that is one who signs a note or who co-signs a note, and the status of a guarantor, who under Ohio law is not a debtor. We expected them to differentiate between we expected them to be able to differentiate between a business under the umbrella of trade or business from a mere investment, which is the ownership of rental property. These are subjects that law students study for months in debtor-creditor law and in income taxation. They're not easy concepts, and I certainly wouldn't expect 12 jurors picked anywhere to really understand those concepts. If there was a mistake made, it certainly wasn't a mistake by the jury. It would have been a mistake on my part, either in not making the differences clear, that would be it. I failed in my presentation in making these concepts clear.